We will just wait a couple of minutes for my co-judge. Um, you don't need to have your cameras or your microphones on while we wait, and I'll come back on once we're ready to start. We'll start about 5 past the hour. Right. I don't know where my co-judge is, but I suggest that we start. Otherwise, we're going to get behind. Aha! My co-judge has just arrived. So I think we should get ready and start now. Unless anyone has any questions at the outset, then I would invite the senior counsel from the appellant team, that's Middlesex N, to begin the moot.
Yes, that would be me, Dua Iqbal. I'm representing Middlesex University as the senior counsel. If it may please, the council seeks permission to address the bench as your lordships, if that's okay.
Traditionally in the DIFC court, you address us as Your Honour, but you can flatter me by
Your
calling me Your
Honour.
Lordships if you want. I don't mind.
The council is appearing before the Honourable Court in the matter of Laith Payne and Razwani on behalf of the appellant under DIFC Court of Appeal on appeal from the Digital Economy Court. There are two main issues involved in the present case. The council will be dealing with the first issue, and my co-counsel will be dealing with the second issue. The council seeks permission to begin with the statement of the facts. Yeah.
You can have a very brief statement of the facts. We're all quite familiar with them, I think.
Okay. So, Clevity is a digital platform on which the users create an account and trade in cryptocurrency. Clavity users must maintain a $50,000 as cash margin in their accounts. This is enforced automatically by the platform software so that users whose cash balances fall below 50,000 are automatically excluded from trading. My client, Mr. Payne's program is called Beta, and it's programmed in such a way that if there are no other users offering to sell YAPL, Beta automatically sells YAPL at a highly inflated price. On June 10th, 2022, Clavity's software underwent a routine upgrade. As a result, there was an error. Clevity wrongfully excluded the market users who had less than $200,000 as a margin in their accounts. So Alpha and Beta automatically concluded a trade, which was a disputed trade, under which Mr. Payne sold 100 YAPL to Ms. Rani. It is common ground between the parties that the disputed trade was concluded at a price 250 times greater than the prevailing market price. The dispute trade was automatically settled by the Clavity platform, which recorded the transfer of 100 YAPL from Mr. Payne to Ms. Rani and debited the Ms. Rani's account for $250,000. When Ms. Rani discovered what happened, she issued proceedings in the DIFC Digital Economy Court, seeking a declaration that the disputed trade was void for unilateral mistake. Mr. Payne issued an application challenging jurisdiction and, in alternative, seeking immediate judgment in his favor of point of law. So the first issue is of relevant mistake, which the council would be establishing on one ground. Under Article 37 of DIFC contract
Can
law.
I just pause you there? I think the first ground of appeal in the problem is the jurisdiction of the DIFC court, namely whether the DIFC court had jurisdiction over the claim under Article 5 of the Judicial Authority Law. Are you going to address that point?
I have not prepared points for that, but I can talk about it. So basically, under my client, I would say does not have jurisdiction under DIFC law because Mr. Payne resides in Oman and Ms. Raz Rani lives in Dubai but not in DIFC. And also in the Clevity platform, the nodes which were operating, there was all the nodes weren't in the DIFC court, so the jurisdiction doesn't fall under DIFC.
Though your colleague is going to, co-counsel is going to address this point in detail.
Yes, I think.
Your co-counsel is going to address this point in detail, is it?
Your Honor,
No, we have another point.
Unilateral mistake.
Okay, but then that jurisdiction issue, who's going to address it? Because if you are overlooking that, that's a crucial issue. And that was the first issue that had to be addressed.
We haven't prepared for that.
Well, I think if you've not prepared submissions on it, then you can't really make them now. Why don't you make whatever submissions you wish to make, and we will hear them and note them. And then senior counsel for the respondent, we expect you to address the jurisdiction issue, as that is the first ground of appeal.
Okay.
So for the moment, the senior appellant can carry on with whatever submissions she wishes to make.
Dua, you may proceed with what you were saying.
Okay. So the first ground that I will be establishing is relevant mistake. It is under Article 37 of the DIFC contract law. Under that, there could not be a relevant mistake within Article 37 of DIFC contract law. Under Article 37(1)(a), a party may only avoid a contract for mistake if and when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation as the party would not have concluded it at all. If the true state of affairs had been known, or the party made the same mistake, or was also mistaken, or caused the mistake, or knew or ought to have known of the mistake, it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. Under Unidroit Principles Article 3.51b, a party may only avoid the contract for mistake if and when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation as the party in error would only have concluded the contract on materially different terms, or would not have concluded it at all if the true state of affairs had been known, and the other party had not at the time of avoidance reasonably acted in reliance on the contract. My client, Mr. Payne, did not know about the mistake because he was asleep at that time. So he couldn't have acted in accordance. And by that time, the contract was already made. And once the contract is made, the withdrawal is not easy. So it was not in the hands of my client to change the contract.
Yes, but ought he have known? That's the test is about what a reasonable person in his situation. So a reasonable person standing in the position of the contracting parties at the time that this contract was concluded would have thought a mistake has been made because neither party intended their programs to operate where there had been a system error on the Clevity platform. What do you say to that point?
There was an error, but my client was not aware of the error. The Clevity platform is more responsible for this because my client's platform beta, it is programmed in a way that it sells at a very highly inflated price. So Miss Rani should have known about that, but again, they were both asleep at the same time, and they couldn't have known of the trade being made. So it was more of Clevity's issue.
Yeah, well, I'm just addressing your submission because, as you read out to me, the mistake was of such importance that a reasonable person in the same situation as the party would not have concluded if all the true state of affairs had been known. So it doesn't matter that they were asleep. One thinks about a reasonable person in the same situation as those parties. If they had known all the facts, known that there was a system error on Clevity, would they have still concluded this contract? And your submission is that they would. Is that right?
Yeah.
And if so, why?
But a reasonable person wouldn't have concluded the trade, but this was not known to them. And once the contract is made, the money was already transferred, and it was harder to come out of the contract.
Well, we're not dealing with the termination of a contract after the event. We're dealing with whether a contract is validly formed, aren't we?
Yes.
So why do you say a reasonable person would still have concluded this contract?
So you need to highlight the reasons for why you would say that as far as reasonable person is concerned. So you have to give your arguments for reasonableness.
I'm sorry, I don't really have.
Okay, well, we'll carry on making whatever submissions you wish.
I was just going to give it to my counsel to make her point.
Well, okay. What happens now is that the senior counsel for the respondent will make their submissions. So if you've got nothing else to say as the senior counsel for the appellant, then thank you very much, and we'll hear from the senior counsel for the respondent.
Okay, thank you.
Good evening, Your Honor.
Good evening.
I'm going to represent the respondent, Mrs. Razrani, on both grounds, the jurisdiction and the mistake.
Well, if you just deal with jurisdiction first, and then there is a right of reply on the appellants, and then we'll deal with the second point afterwards. So if you just deal with jurisdiction for the moment.
Yes. First, I seek permission to start first by giving a brief on the facts of the case.
You don't need to do that.
Okay, I will go straight into the point. Ground one, which is related to the DIFC court, if the DIFC court have jurisdiction over the claim. From my point of view, the judge was correct in concluding that the DIFC court had the jurisdiction under the Article 5A1 subsection B because Clevity operated through a distributed ledger, one of its nodes in the DIFC. Now I will go through a little bit of defining and giving some characteristics of the distributed ledger and the nodes. Distributed ledger is a decentralized network that is geographically distributed across many nodes in different sites and countries. What characterizes the nodes that every node is considered a mirror copy of whole the platform. That means every node hosts every transaction and verifies it. Where every transaction must go through the node that first hosts it and then validate it by the nodes and then broadcast it to every node. Here, I want to cite citing U.S. Securities and Exchange Commission and I.M. Balina, 2022, Western District, Texas, number 950, which is founded in page 19 of my skeleton, my bundle. According to this precedent, here the court in the U.S. concluded and said that it has a jurisdiction because about this precedent is about Ethereum cryptocurrency. The court considered that because this Ethereum transaction was validated by a network of nodes on Ethereum blockchain, which was founded in the US, thus it considered that those transactions took place in the United States and considered that it has a jurisdiction over that claim. Here, similarly,
just pausing there, just looking at your authority. The quotation that you've cited at paragraph 19, page 19, says which are clustered more densely in the United States than in any other country. So it looks like what was important for the US court was not just that there was one node in the relevant state, but that there were many nodes that are clustered more densely in the United States than in other countries. Whereas here you've got a number of nodes in a number of countries, and all we know is that there is one node in the DIFC. So does this really support the proposition that a single node is sufficient to give a court jurisdiction? Hello? I don't know whether you're still with us.
I think we have lost him.
I think we have. Safa, are you back?
Your Honor?
Sorry, we lost you for a few minutes. Did you hear my question?
I guess it's bad network.
Your Honor, can you hear me?
I can hear you. Don't worry about having your camera on if that makes if that's going to slow you down. We're really more interested in what you say.
Can you hear me?
I can hear you.
Sorry, I had a technical issue. Sorry.
My question, did you hear my question? About
no, I think it's okay. Great.
So in the Balina case, the case seemed to turn on the nodes being clustered more
about
densely.
that the said an state of United States.
Yes.
In the US rather than any other country. Yes. Right.
Yes. What do you say about that?
Okay, it's a point of view, but as I looked, as I let's say give some when I read the decision and try to explain it, and it's what is important is the concept, not the number of nodes. The concept and how the technical or how the technique of nodes and blockchain and Ethereum and the cryptocurrency work, because every node it's the following: every node in the platform revise first host the transaction and revise it and validates it to make sure that this transaction is right, is correct. And then broadcast into the other nodes until all the platform.
Thank you. You can carry on with your submissions.
Thank you, Your Honor. Now I will continue with with the first ground. Also, there's another one which is another citation I will talk about later. Now I will refer to the Article 5A, number 1, subsection B of the Judicial Authority Law, which states that the Court of First Instance shall have exclusive jurisdiction to hear and determine civil or commercial claims and action arising out or relating to a contract or promised contract, whether partly or wholly concluded, finalized, or performed within the IFC, or will be performed or is supposed to be performed within the IFC pursuant to express or implied terms stipulated in the contract. According to this article, and if we want to apply this article to the example or the situation we have, because the node is located within the DIFC, and because every node gives or play an essential wearing a transaction, because it's broadcasted and it verifies it, and then it's hosted, verifies it, and then broadcast it to the other nodes until all the platform. Thus, this claim was arise of an incident that took place within the DIFC. Thus, DIFC court shall have authority in accordance with the Article 5A 1B. And here I want to cite another precedent, which is the Al-Khurafi versus Bank Saracen, 2011, case number 3 and 5 January 2012, which is founded in page 13 of my bundle. According to this precedent, the IFC court shall have jurisdiction if an incident or transaction, that incident that was a result of a commercial activity was in the DIFC, thus the DIFC courts have a jurisdiction.
Can I just put a point to you? If it is sufficient for a node, the existence of a node in any particular country to give that court jurisdiction, then isn't there a problem? Yeah. Doesn't that mean that where these businesses operate and they have hundreds of nodes in many, many jurisdictions, that you're going to get hundreds of courts potentially with jurisdiction over all these claims, and you're going to have lots and lots of expensive litigation about which courts ought to hear them? And is that not a reason to construe the law narrowly, in a way to confine it only to those sorts of transactions that have some greater nexus with the DIFC than simply the existence of a node? Yes,
Your Honor. Of course, in this case, this problem will occur because every node, but this is the technique, because the technique works like this. So we can't just consider that we need a particular number of nodes to give the jurisdiction to the place where the nodes are founded. Here we might like give some let's say conventions, word conventions, to try to
we're losing you. So I if you can hear me, I didn't get the last minute of what you said.
To put some rules to
Alpha, why don't you switch off your video and just use the just switch off your video, because your bandwidth is slow, so we are losing you. We can't hear you. Matthew, can you hear me?
I can hear you.
Yeah.
Yes.
So
Safa, I think Salman's right. If you turn your video off and just speak, that might be easier.
I think we have lost him again.
Maybe we have. Still appearing in my participant list.
No,
Safa, can you?
he's there, but I think it's just the bandwidth.
Your
So-
Honor.
We can hear you. We can hear you now.
Sorry,
Continue
but the internet is very. I don't know what's happening. The morning was good. Now it's not working. Can I continue with my camera shut down in order to have stability in internet?
Yes, please do.
I'm sorry, Your Honor. I repeat my answer. Did you hear my answer, or I will repeat it?
Please repeat it. I caught the first half, but not the second half.
Okay, great. I will repeat it, Your Honor. I was saying that the technique works like this. It's hard to, let's say, to legislate in a specific country a law that states, let's say, 50% of the notes must be found in this state or this country or this or under the jurisdiction of a specific court. The technique is is really complicated. This technique of notes, because it's the characteristics of this ledger of these ledgers are they are decentralized. There is no center of these notes. Let's say as a person who runs it, or a specific entity or specific state. This is centralized. Every person and everywhere can enter. Let's say buy a Bitcoin or an Ethereum, or like the case in this case, YAPL, to program a specific program and trade through this program. So I see that it may be this problem can be solved through an international convention. There must be an international cooperation regarding this issue, because it's very hard because of this technique that is decentralized, not centralized ledger. No one is let's say is controlling the specific technique.
Thank you. Please continue with your submissions.
Finally, after we talked about the characteristics of the distributed ledgers and the nodes, and as I stated before, that because nodes and that this technique is about that every node host and verify and then broadcast that the every transaction to the other nodes and to the platform, the old platform. Thus, the DIFC courts have jurisdiction over the claim in accordance to the Article 5A1B. Your Honor.
Yes. Thank you very much. That's all your submissions on the jurisdiction point?
Yes, Your Honor.
Thank you. I will invite senior counsel for the appellant, if she's got 5 minutes, if she wishes to say anything in reply on the jurisdiction question. But if not, then we'll move to the junior counsel for the appellant.
I would just like to say that my client was residing in Oman, and Miss Raz Rani is also residing in Dubai, but she is not in the IFC jurisdiction. And the nodes which were operating, there was only one node which was operating, all the others weren't. So there isn't a very highly likely chance that the node they operated through was the one in the IFC.
Do you say that the place where the parties resides makes any difference at all, because obviously the DIFC court frequently hears disputes between parties, neither of whom are resident in the DIFC. So is your point based on their location or based on the node?
It's based on both. It's mostly based on the node, but also their location, because my
Okay.
client was not residing in UAE or Dubai.
But and so as regards the node, just so I can understand your submission, the way that the distributed ledger technology works is that when a transaction takes place, it's recorded on each node. So every node is important and unimportant in a sense, because if one node were to fail, the transaction would be recorded on all the other nodes, so that rather than there being one database that is held centrally, there are hundreds of databases that are all identical and update together that are held decentrally. So we know that this transaction will be recorded on this DIFC node, just as it'll be recorded on all the other nodes in all the other jurisdictions. So how do you say that affects the jurisdiction question?
I have no comment.
Okay, thank you very much. So
Thank
we will now hear from the junior counsel for the appellant.
The counsel seeks permission to proceed with second pleadings.
Please go ahead.
Your Honor, our second issue put forward is one of the unilateral mistakes and how it wasn't a unilateral mistake. Unilateral mistake defined by Black's Law Dictionary is where one occurs when one party is mistaken as to the subject matter or terms put forward in the agreement. Here, my client, Mr. Payne, did not and couldn't have known about the glitch that occurred, so could not be any grounds to avoid the disputed trades or say it was a unilateral mistake. My second point.
Sorry, just pausing there. Unilateral mistake is where one party makes a mistake. It's Miss Rani, isn't it? The respondent. She says that she made a mistake because she would not have concluded this transaction had she known all the facts. So she's the one who says that she made a mistake. So it's submitting that the appellant didn't make a mistake is not an answer to a case based on unilateral mistake.
My point here is that it wasn't an unilateral mistake, as Ms. Rani says that it was an unilateral mistake, but it wasn't an unilateral mistake because they weren't aware about the glitch. And unilateral mistake is when one party is mistaken to the agreement or the terms in the contract.
Okay, carry on.
My second point forward is the general rule of common law was that if one party had made a mistake as to the terms of the contract and that was mistaken to the other party, then the contract wouldn't be binding. But here they weren't aware about the mistake, about the glitch that happened. So on no grounds they couldn't say that the contract is not binding or to avoid the disputed trade.
So are you saying that a contract that is concluded through computer programs can never be avoided for unilateral mistake? Because in all cases where a computer concludes a contract on behalf of a human being, the human being isn't necessarily aware of the precise terms at the time the contract is formed, because the contract is formed automatically. So is your submission, the effect of your submission would be that a contract that's concluded through two computer programs could never be void for unilateral mistake. Is that right? Or do you think there might be some circumstances where there could be the operation of that principle?
Maybe some circumstances, but there might probably be some exceptions.
What would be the circumstance? Can you think of an example? Because at the moment it sounds like you're saying this doctrine can never apply to these sorts of cases. And what
reference to a case for a unilateral mistake.
Go on then, tell me where to find it.
So
It's not in, I don't think this is cited in your skeleton argument, is it?
no, I don't think so. It's in my skeleton argument.
Right, what's the case you should tell us about?
The case is Hartog versus Cullen and Shields, the 1939 case.
Oh, right, yes.
So in that case, the seller had sold the goods, but not for the correct price, and the buyer was caught by the buyer's attention immediately, and that's when the contract was like void, because the mistake was.
But in this case, the moment the parties woke up, it was obvious that a mistake had happened, because neither of them had anticipated that their programs were going to be working when there was essentially a glitch on the platform. And that's what Lord Mance said in Coyen. He said the law's got to move on. You've got to imagine what a reasonable trader in the position of the parties at the time the contract was formed would have concluded.
But here the money was already transferred and they came to settle at a point.
But the money was transferred automatically.
But that was the whole issue of, as my senior appellant said, that was the whole issue of the Clevity platform. It was their issue that there was a glitch.
Yes, but that can give rise to a mistake, can't it? Just like if I go on Amazon and I see that Amazon has made an error on their website, and there is somebody who is on Amazon selling iPads, and the Amazon software makes a mistake and shows me a price of $1 for the latest iPad, and I click to buy, and I it's obvious to me as a human being that a mistake has been made, because iPads are not sold for $1. They're, let's say for the sake of argument, they're sold for several $100s. That would be a case of unilateral mistake, because the seller, whoever it was, wasn't intending to sell at that price. That only happened because there was a mistake on the Amazon website, and I'm seeking essentially to take advantage of it. And as I understand it, your submission is that this case is different only because neither of the parties were aware of what was actually going on at the time, because they just programmed computers to act on their behalf and they were asleep. But why should that really make a difference is, I think, the nub of the issue.
Because the parties weren't aware about the glitch going on, and just one party saying that, yes, now it's a unilateral mistake, doesn't really stand on any ground to avoid the disputed trade.
Right, okay. Please carry on with your submissions.
That is it for my point about the unilateral mistake.
Okay, thank you very much. In which case, we will hear from the respondent again. And again, please don't worry about your camera, just speak.
Yes, Your Honor, thank you. I'm sorry for the technical issues.
It's all right, it's not your fault.
With the ground 2. Thank you, Your Honor. Regarding the ground 2, I consider from my point of view that the judge was correct in concluding that for the purpose of the claim to avoid the dispute trade, it was sufficient for the purpose of satisfying Article 37(1)(a) of the DIFC Court law that the respondent showed that a reasonable trader with the knowledge of a circumstance surrounding the transaction would have concluded that dispute trade was the result of an error. Here, first, I want to start with the Article 37(1)(a) and to give a brief explanation in order to try to convince and prove that the first instance court actually the decision of the court of first instance was correct. First, the Article 37(1)(a) states that a party may only avoid a contract for mistake if, when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation as the party would have not concluded it at all if the true state of affairs has been known. First, I will start with this condition. According to what we stated or what we said in the fact, first the respondent, Mrs. Had programmed Alpha in a way to buy YAPL at best possible price available on the Clavity platform. Her consent was to buy this YAPL with the best prices, not a price that was derived or an effect of an error that made an inflation and the inflation on the prices of the cryptocurrency and was an abnormal price. This is one. Number two, the price that was 1 to 150 times greater than the normal price is considered, of course, considered as this trade is considered as an unreasonable trade, where no one, whether the respondent, whether any reasonable person would buy an YAPL or any cryptocurrency or any type of any good with this price, which is 250 times the normal price. And here I'm citing to the precedents, which is Halson versus Hazel, DIFC court number 86, 18 May 2017, which is found on page 16 of my bundle, and Gilad LLC versus Gilad LLC in number 84, 3 October 2016. These two precedents was talking about the mistake. According to the first one, which is located in article 4 and page 14 of my page 14 and 15 of my bundle, the court considered that a party may only avoid a contract for mistake when the contract was concluded if that mistake was of such importance that a reasonable person in the same situation as the party would not conclude it at all if the true states of affairs had been known. Now, if we refer back to our case, the price that was the transaction was done according to it was an incorrect and non-actual price, where there an excessive advantage for one of the parties along the other one. Also, by referring to the second the precedent, which is Halson versus Hazel in page 16, also the court considered that it's clear for the defendant's submission that it would not have entered into the compromise agreement in its final form had it been aware of the true state of affairs. So, according to this, according to what I've said, in return to the case, the first condition, which is it was a great mistake, thus the condition is not. Now I will proceed with my with the ground two. The article.
Can I just put a question to you about the reasonable person?
Yes.
Might it not be said against you that if you decide to trade by programming a computer program and setting it loose on a platform with no other restrictions, so don't buy if the price goes above this level, or don't sell if it goes at this level, that you take the risk that there are changes in the market, whatever happens, whatever the cause of that is, whether it's an accident on the platform or just how other users behave, don't you take the risk that something happens that your program responds to and you're then committed to the contract? So might the reasonable trader actually in this scenario not think, well, actually the parties may not have intended to enter into this particular contract, but they intended to be offering to buy and sell in these sorts of conditions, and so they're stuck with the contract that their programs eventually concluded. What do you say to that?
Yes, of course. There's in every work we go through, there's a presumption of risk, but also the risk must be somehow reasonable one. That means this transaction was because of an error. This error is it's the first time it takes place, because as we read in the essential background and the facts of the case, it was a random error. This is one. Number two, as I said, there must be a reasonable one, a reasonable risk factor. That means, of course, in cryptocurrency, it is there's the demand, there's the offer and demand. But the price in this case was very high in a way. It was abnormal one, not an reasonable one. Everyone must take a risk, especially in the cryptocurrency and other markets. But this high price is abnormal. So it's not an equity to leave the respondent in this case without in this contract, because there's an excessive advantage for one party on the other one. There's no equilibrium or type of equity between the obligations of the parties. The obligation and the interest of the parties.
Thank you. You can carry on with your submissions.
Yes. The article continues to say, and the other party made the same mistake, or was also mistaken, or caused the mistake, or knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party alone. As I said before, it was an abnormal price, so it was unreasonable according to the concept of fair and equity to leave the respondent in this error and to apply the contract and to consider that this contract is correct and it's legal and it's not voidable, because there is no equity in the obligations between and the interest between the parties.
What earlier Matthew had suggested and alluded to, I'm asking you again.
Yes.
Where a computer has been authorized to conduct business on your behalf.
Yes.
If the computer enters into a contract or takes certain actions, aren't the people who have authorized the computer or programmed the computer in such a way responsible for the actions of the computer? So the vicarious liability concept, wouldn't that come into play here? Wouldn't that go against your argument?
Your Honor, it's correct that if a computer made this error, I can't bring him before the court. I must go to the programmer who programmed this. The respondent programmed its program to buy Yapel at a price that is a good price, not a very inflated price. Whereas the appellant, the programming of his program was a kind of, if we say that he might know that this an error or a problem will occur, and this will consequence as a result of his programming.
Okay, you may continue with your arguments.
Finally, I want to say that, as I stated before, this disputed trade took place due to a major error. Only I want to add something now. I remember to what I've said before regarding the computers and the programs. The most important is not as to we must go back to the status of the programmer. Let's say we must say that just this programmer in an abnormal and unreasonable time and a normal time will accept this trade. For me, this is the question, or the way we must here try to solve the case according to, because what is important is the mentality and the status of the person who is the programmer, not the computer. Finally, I want to say that this disputed trade that took place to a major error, where if this error hasn't taken place, this disputed trade wouldn't have been concluded. Finally, I ask Your Honor to dismiss the appearance, dismiss the appeal due to because of the DRC court have jurisdiction, and finally because of the unilateral mistake. And thank you.
Thank you very much for those submissions. So now the junior counsel for the appellant has 5 minutes to respond if she wishes.
No, Your Honor, I think we covered and we're satisfied with the points we gave.
Thank you very much. In which case, thank you all for participating and for giving up your time. Salman and I are going to submit our marks to the people who organize it, and you will find out whether you progress to the next rounds, which will be heard tomorrow. I think the quarterfinals at 11 o'clock Dubai time. Unless any of you have any questions, then you can all log off and have a break, I think.
Thank you, Your Honor.
Thank you,
Thank
everyone.
you for time. Thank you for your time and your effort. Thank you.
It's a pleasure. Thank you, everyone.